My name is LaDerica Christian, and I'm the Voting Rights Outreach Coordinator at the Texas Civil Rights Project. I'm here to express our concerns regarding this body's proposal to undertake an unprecedented mid-decade redistricting, including the creation of this Redistricting Advisory Committee. My testimony today seeks to respond to and correct information in a memorandum provided to Commissioner Myers by the law offices of Tony McDonald, or the McDonald Memo, on May 24, 2025, so that you may fully understand your legal obligations and the risk of the current redistricting plan, which bears certain hallmarks of intentional racial discrimination. In 2021, it was lawful for Fort Bend to rely on race to the extent it was necessary to create legally required coalition districts, because at that time, Fifth Circuit case law recognized that coalition districts were protected by the Voting Rights Act. Contrary to the assertions in the McDonald Memo, any subsequent changes in the law do not retroactively make the map drawn in 2021 unlawful. Therefore, Fort Bend cannot rely on this justification to initiate this mid-decade redistricting. Further, both the Supreme Court and the Fifth Circuit have recognized that complying with the Voting Rights Act is a compelling reason for governments to rely on race in the redistricting process, and thus, when narrowly tailored, does not constitute unconstitutional racial gerrymandering. The McDonald Memo points to the Pettyway v. Galveston County decision from the Fifth Circuit to suggest that governments are not permitted to use race to prevent vote dilution of a so-called racial coalition, and thus argues that Pettyway requires these coalition districts be redrawn. This analysis is fatally flawed for two reasons. First, Pettyway was not decided until 2024, a full 3 years after the current maps were drawn. Even more importantly, though, Pettyway neither sanctions nor directs the intentional dismantling of existing minority coalition districts, and assertions to the contrary mischaracterize the Fifth Circuit's decision. Instead, the intentional dismantling of existing minority coalition districts raised grave concerns about intentional racial discrimination under both the 14th and 15th Amendments. For these reasons, the Commissioner's Court should not rely on the legal analysis provided by the McDonald Memo and should instead retain the current Commissioner precinct lines. Thank you.